So the background is that a bill called Bill number 7, which was introduced by the government. So that bill seeks to amend the Constitution and bring different, proposed articles within the framework of our Constitution. So after that Bill 7 was tabled in Parliament, it was actually passed in Parliament, and it now became Amendment Act number 13. Okay, so this Act number 13 is an act that has introduced quite a number of things, more especially in the election process, in the election system. The Act number 13 introduces what is called the proportional representation system in our electoral process. It secondly reintroduces the members of parliament to go back and start sitting in our local authorities. So this act now, this constitutional amendment, be actualized, and there's need for the electoral process Act number 35 of 2016 to be revisited. And you are fully aware that the Electoral Commission of Zambia has embarked on the process of ensuring that the Electoral Processes Act number 35 of 2016 is being reviewed, and with that effect is an electoral process bill that the ECZ has circulated for people to make their own papers. Of course, it introduces a lot of changes that will be commensurate to the changes that have happened within the framework of the Constitution. It does not limit my right to exercise my right to vote. I still retain my universal suffrage, that is my franchise. So what the bill is proposing is that within the framework of 180 days before the next general election, in an event that circumstances happen, like the passing on of an incumbent, maybe ward councillor, incumbent member of parliament, including those that come into parliamentary system, no by-election can be held within that 180 days period running into 2020, into the August general elections. Yes, like I've said, my voting rights are still retained. Why? Because like I said, we now have 3 types of elections within our electoral system. So the first election that we have is the majoritarian system, okay, or the so-called 50% and more. That is at presidential level. So for one to win the presidential level, one must have 50% of the valid votes cast at presidential level plus 1 or above 50. That is the first electoral system, which we have been using from the time that our constitution was amended in 2016. Then the second system is also another system that we have been using at parliamentary and local government level. That is a first past the post system, where the winner takes it all. It's a simple majority. Whoever's got the majority votes in any election wins. So now the third one that has been introduced is the proportional representation system. So if you read the Act number 13 that we're talking about, it introduces 40 seats that are proportionally reserved. Amongst those 40 seats, it introduces 20 seats that are reserved for women, 15 seats that are reserved for the youth, and 5 seats that are reserved for persons with disabilities. So those seats are not, they are voted for, yes, in a different way, but they are not voted for direct like the way we vote for a presidential candidate, parliamentary candidate, and local government candidates. Those seats are allocated in a different way as prescribed by the proposed electoral process bill. Yes, like I said, this is a proposed bill, and a bill is a proposed law. So to actualize or to prescribe what the Constitution through Amendment Act number 13 is saying, there's need to have the Electoral Processes Act number 35 of 2016 that we have been using. There's need to have it amended so that we prescribe further, okay, how those seats will be allocated. So now you realize that, in different jurisdictions, they use a different system to allocate those seats. So in this regard, in our Zambian case, the Electoral Commission of Zambia, through that bill, they're proposing a quota system. So in a quota system, it's a situation where political parties contesting elections are requested to prepare a party list. And on this party list, they're supposed to have 20 names, for women, how they get that the bill is proposing a democratic process. On the youth seats, they present a list of 15 youths. On the persons with disability, they present a list of say 5 persons with disability. So this list is submitted to the Electoral Commission of Zambia, verified, and all the processes and the requirements must be made. So you realize that the political parties that have not submitted political party lists, their votes at presidential level cannot be used to calculate the percentage in terms of vote distribution, including those that are contesting as independent presidential candidates. So the total number of valid votes at presidential level, okay, are the ones that are going to be used to ascertain the allocation of the proportional representation seats. For example, if you want to get a quota to ascertain the number of seats that you have obtained in that particular election as allocated proportionally, you need, for example, if the total number of valid votes is 2 million, then me as a presidential candidate, I get maybe 500,000. So for us to arrive at a quota, we must divide that 2 million into my 200,000 votes, then you get a quota. So that quota you get, you multiply it by the number of seats allocated to women. You multiply it by 20. Maybe it's going to give you maybe 3 seats. So those are the 3 seats my political party is going to get and allocated to women. If you multiply it by 15, it gives me 2 seats. Those are the 2 seats for the youths. By 5, it gives you 1 seat. That is a seat for the person with disability. So yes, as a voter, the moment this bill is passed into law, it has got the schedules, or annexes, where they have given examples how these seats are going to be calculated based on the total valid votes obtained by a person who is running as a presidential candidate, not those that have not submitted the party list, not those that are running as independent. So the most important aspect to political parties is to ensure that their political parties follow what the ECZ will prescribe in as far as submitting the party list is concerned, in order for their votes to be calculated and allocated to those seats allocated proportionally for women, youths, and persons with disabilities. Yeah, I think the proponents of Bill 7 looked at an electoral process that is inclusive. Okay, we are coming from the background where our electoral environment and political environment have been highly commercialized and have been highly competitive and in most cases discriminatory. So you realize that in as much as Zambia is a part to a lot of protocols like the SADC Agenda Protocol, which speaks to women representation at different levels, including elective spaces, you realize that Zambia has actually struggled to have women representation at the council chambers, women representation at parliamentary level, as well as youth representation, and also the representation of persons with disabilities. So the proponents of Bill 7 say there's need for us to ensure that we include an electoral system that almost automatically gives spaces to this segment of society that I've mentioned, gives spaces to our women, gives spaces to our youths, gives spaces to the persons with disabilities. Hence the proposal to have 40 seats proportionally allocated. So these seats are not elective seats. They are seats that are allocated based on the performance of a particular presidential candidate in a general election. So, that is the challenge which was seen in the electoral process. So that even if you subject other women to a competitive electoral environment, at least you are assured that there will be 40 seats that will be automatically occupied by women, occupied by youths, occupied by persons with disabilities. So when you read the proposed law, the Electoral Process Bill 2026, it still retains, like I've said, the other two electoral systems. So there are no changes on how we elect the president. So there will be no changes on how we elect our members of parliament, how we elect our mayors, how we elect our council chairpersons, how we elect our councillors. Okay, so the only condition now that has been introduced is the proportional representation system, and also now the bill is also proposing how those seats, like I've explained, are going to be allocated. All right, so that one must not worry me as a voter, because I'll still go, God willing, on the 13th August to go and elect the president, the member of parliament, the mayor or the council chairperson, also the ward councillor. Those will be elected. But for those to occupy proportional representation seats, they need to ensure that they accumulate votes at national level, because only valid presidential votes at national level will be used to allocate parliamentary seats. Then at district level now, the composition of the council varies. For example, the bill is proposing that the council with local ward seats of maybe 21 and above have been given a specific number of women to go and occupy seats proportionally, youths and persons with disabilities. A bigger council with 35 ward councillors and above, also they have been given a specific number. So the numbers vary. Okay, so what is critical is to ensure that as we are interrogating this bill, also we have to bear in mind that the presidential vote at district level are the votes that are going to be used to allocate seats at local government proportionally. So that has been the concern of different stakeholders, that the Electoral Commission of Zambia is proposing quite a good number of changes within the electoral legal regime. But they are not also trying to strengthen the mandate of the Electoral Commission of Zambia. You are fully aware that there have been complaints about the independence of the Electoral Commission of Zambia. All right? So again, administratively, the Electoral Commission of Zambia still operates through local government authorities. So you realize that most of the staff that they use to run or administer elections are staff from local authorities, are staff from other civil service, ministries or departments. Okay, so that in itself takes away the substantive tasks or functions of these officers within their jurisdictions, because they are committing their time, most especially during the time of elections like this one, where we're going into in August, to commit themselves to the functions of the Electoral Commission of Zambia. So what we are saying that we want to see an expanded law that is going to also, one, expand the mandate of the ECZ. The Constitution gives powers to the Electoral Commission of Zambia to decentralize. So we want to see a law that is going to have an ECZ that is decentralized, that has got presence at district level, okay, gradually. We want to see a commission that has got power to bite. Yes, this time they are proposing that, where in the past there used to be cries of ECZ not exercising the power to even bar someone who has been seen to be, involving themselves in electoral malpractices like electoral corruption, electoral bribery. Such things, such complaints were coming forth, but we have never seen in the past ECZ exercising such biting, teeth. But we want to see a strengthened law that is going to give them such powers also. And also we want to see maybe a law that is going to ensure that the appointment of the commissioners at the Electoral Commission of Zambia is done in a very transparent and accountable way, where maybe we embark on a vetting process, where the stakeholders must also take a keen interest in ensuring that they participate in the manner the commissioners at the commission are appointed. That is what we want to see. So there are certain also elements within the bill, I think we'll come to that, where stakeholders have expressed their reservations on. Yes, so at different levels, like I've said, so there are now different, benchmarks that are being proposed. For example, for you to be validly nominated by the Electoral Commission of Zambia to appear on the ballot, you are supposed to, if you're sponsored by a political party, you're supposed to have a certificate of adoption, which they have defined in the draft bill, signed by the Secretary General of a political party, recognized by the Registrar of Societies. So no, this is a society that registers political parties. All right? So now, for you to contest as a councillor, for you to contest as a mayor or council chairperson, a member of parliament, or a presidential candidate, one person from a political party recognized by the Registrar of Societies, acting as SG, must sign these adoption certificates. So we are saying such a process is quite a tedious process, and it's a process that can actually eventually franchise other people want to participate in the electoral process as candidates. We are talking about 1,885, if I'm not mistaken, words, all right? We are talking about 116 mayors, local council chairpersons. Then we are talking about 126 parliamentary seats. You are fully aware that the Constitutional Amendment Act number 13 provides that there will be 226 constituency-based seats. We have currently 156. So with that delimitation in the process, they're going to add 70 more parliamentary seats, totaling 226 constituency-based. So now, we are giving the powers to one person to sign all those adoption certificates. So that in itself is a recipe for confusion within the political parties, because there are certain political parties that do not have secretary generals. Then there are also certain individuals who may not have the integrity, who can easily be bought and, 11th hour, they run away and they can't sign these certificates of adoption. So we are proposing that why can't you have any person performing administrative functions within a political party be assigned to do such undertaking? Why can't you decentralize also to political parties? Political parties have got, ward officials, constituency officials. Why can't you give them district officials, provincial officials? Why can't you give them that mandate to sign certificates of adoption as long as they're recognized by political parties? That in itself is going to contribute to, playing an even electoral political environment. Then also the aspect of political party list submission, all right? The draft is not clear. It is not instructive on how political parties are going to conduct their intra-party democratic elections for them to come up with the party lists of women, youths, and persons with disability. What we want to see is a law that is very instructive. We have been having reservations on this undertaking as stakeholders because we have not fully actualized Article 60 of our Constitution, which demands that political parties must have a national character, political parties must have primary elections. So could have used such primary elections maybe for political parties to democratically come up with those lists. But if you leave it vague like that, it's a recipe for anarchy, it's a recipe for electoral and political corruption within these political parties. And you are fully aware that these political parties are not funded. So very few political parties have got the financial muscle to go maybe in the provinces to go and conduct these elections, or to even bring people to come and form an electoral college in Osaka for them to come up with such party lists. And also there are other suggestions on how a party list can be accepted or not accepted. And the time frame is given for the ECZ to ensure that they go back to that particular political party to rectify their party lists. But we are saying all those things must be clear, because one of the principles of elections is that the electoral process must be simple, must be inclusive, and must be transparent.